The President of the United States of America is the elected head of state and head of government of the United States. The President leads the executive branch of the federal government and is the Commander-in-Chief of the United States Armed Forces. The President of the United States is considered one of the world's most powerful people, leading the world's only contemporary superpower. The role includes being the Commander-in-Chief of the world's most expensive military with the largest nuclear arsenal and leading the nation with the largest economy by real and nominal GDP. The office of the President holds significant hard and soft power both in the United States and abroad. Article 2 of the U.S. Constitution vests the executive power of the United States in the President. The power includes execution of federal law, alongside the responsibility of appointing federal executive, diplomatic, regulatory and judicial officers, and concluding treaties with foreign powers with the advice and consent of the Senate. The President is further empowered to grant federal pardons and reprieves, and to convene and adjourn either or both houses of Congress under extraordinary circumstances. The President is largely responsible for dictating the legislative agenda of the party to which the President is enrolled. The President also directs the foreign and domestic policy of the United States. Since the founding of the United States, the power of the President and the federal government has grown substantially. The President is indirectly elected by the people through the Electoral College to a 4-year term, and is one of only 2 nationally elected federal offices, the other being the Vice President of the United States. The 22nd Amendment, adopted in 1951, prohibits anyone from ever being elected to the presidency for a 3rd full term. It also prohibits a person from being elected to the presidency more than once if that person previously had served as president, or acting president, for more than 2 years of another person's term as president. In all, 43 individuals have served 44 presidencies spanning 56 full 4-year terms. On January 20, 2009, Barack Obama became the 44th and current president. On November 6, 2012, he was re-elected and is currently serving the 57th term. The next presidential election is scheduled to take place on November 8, 2016. On January 20, 2017, the newly elected president will take office. Origin: in 1776, the 13 colonies, acting through the Second Continental Congress, declared political independence from Great Britain during the American Revolution. The new states, though independent of each other as nation-states, recognized the necessity of closely coordinating their efforts against the British, desiring to avoid anything that remotely resembled a monarchy. Congress negotiated the Articles of Confederation to establish a weak alliance between the states. As a central authority, Congress under the Articles was without any legislative power. It could make its own resolutions, determinations, and regulations, but not any laws, nor any taxes or local commercial regulations enforceable upon citizens. This institutional design reflected the conception of how Americans believed the deposed British system of Crown and Parliament ought to have functioned with respect to the royal dominion, a superintending body for matters that concerned the entire empire. Out from under any monarchy, the states assigned some formerly royal prerogatives to Congress, while severally lodging the rest within their own respective state governments. Only after all the states agreed to a resolution settling competing Western land claims did the Articles take effect on March 1, 1781, when Maryland became the final state to ratify them. In 1783, the Treaty of Paris secured independence for each of the former colonies. With peace at hand, the states each turned toward their own internal affairs. By 1786, Americans found the continental borders besieged and weak, the respective economies in crises as neighboring states agitated trade rivalries with one another, witnessed the hard currency pouring into foreign markets to pay for imports, the Mediterranean commerce preyed upon by North African pirates, and the foreign-financed Revolutionary War debts unpaid and accruing interest. Civil and political unrest loomed. Following the successful resolution of commercial and fishing disputes between Virginia and Maryland at the Mount Vernon Conference in 1785, Virginia called for a trade conference between all the states, set for September 1786 in Annapolis, Maryland, with an aim toward resolving further-reaching interstate commercial antagonisms. When the convention failed for lack of attendance due to suspicions among most of the other states, the Annapolis delegates called for a convention to offer revisions to the Articles, to be held the next spring in Philadelphia. Prospects for the next convention appeared bleak until James Madison and Edmund Randolph succeeded in securing George Washington's attendance to Philadelphia as a delegate for Virginia. When the Constitutional Convention convened in May 1787, the 12 state delegations in attendance brought with them an accumulated experience over a diverse set of institutional arrangements between legislative and executive branches from within the respective state governments. Most states maintained a weak executive without veto or appointment powers, elected annually by the legislature to a single term only, sharing power with an executive council, and counted by a strong legislature. New York offered the greatest exception, having a strong, unitary governor with veto and appointment power elected to a 3-year term, and eligible for re-election to an indefinite number of terms thereafter. It was through the closed-door negotiations at Philadelphia that the presidency framed in the U.S. Constitution emerged. Powers and duties. Article 1 Legislative role. The first power the Constitution confers upon the President is the veto. The presentment clause requires any bill passed by Congress to be presented to the President before it can become law. Once the legislation has been presented, the President has 3 options: sign the legislation, the bill then becomes law; veto the legislation and return it to Congress, expressing any objections, the bill does not become law, unless each House of Congress votes to override the veto by a 2/3 vote. Take no action. In this instance, the President neither signs nor vetoes the legislation. After 10 days, not counting Sundays, 2 possible outcomes emerge. If Congress is still convened, the bill becomes law. If Congress has adjourned, thus preventing the return of the legislation, the bill does not become law. This latter outcome is known as the pocket veto. In 1996, Congress attempted to enhance the President's veto power with the Line-Item Veto Act. The legislation empowered the President to sign any spending bill into law while simultaneously striking certain spending items within the bill, particularly any new spending, any amount of discretionary spending, or any new limited tax benefit. Congress could then repass the particular item. If the President then vetoed the new legislation, Congress could override the veto by its ordinary means, a 2/3 vote in both houses. In Clinton v. City of New York, 524 U.S. 417, the U.S. Supreme Court ruled such a legislative alteration of the veto power to be unconstitutional. Article 2 Executive powers. War and foreign affairs powers. Perhaps the most important of all presidential powers is the command of the United States Armed Forces as its commander-in-chief. while the power to declare war is constitutionally vested in Congress. The President has ultimate responsibility for direction and disposition of the military. The present-day operational command of the armed forces is normally exercised through the Secretary of Defense, with assistance of the Chairman of the Joint Chiefs of Staff, to the combatant commands, as outlined in the presidentially approved Unified Command Plan. The framers of the Constitution took care to limit the President's powers regarding the military. Alexander Hamilton explains this in Federalist No. 69. The President is to be Commander-in-Chief of the Army and Navy of the United States. It would amount to nothing more than the supreme command and direction of the military and naval forces, while that of the British King extends to the declaring of war and to the raising and regulating of fleets and armies, all which would appertain to the legislature. Congress, pursuant to the War Powers Resolution, must authorize any troop deployments longer than 60 days, although that process relies on triggering mechanisms that have never been employed, rendering it ineffectual. Additionally, Congress provides a check to presidential military power through its control over military spending and regulation. While historically presidents initiated the process for going to war, critics have charged that there have been several conflicts in which presidents did not get official declarations, including Theodore Roosevelt's military move into Panama in 1903, the Korean War, the Vietnam War, and the invasions of Grenada in 1983 and Panama in 1990. Along with the armed forces, the President also directs U.S. foreign policy through the Department of State and the Department of Defense. The President is responsible for the protection of Americans abroad and of foreign nationals in the United States. The President decides whether to recognize new nations and new governments, and negotiates treaties with other nations, which become binding on the United States when approved by two-thirds vote of the Senate. Although not constitutionally provided, presidents also sometimes employ executive agreements in foreign relations. These agreements frequently regard administrative policy choices germane to executive power. For example, the extent to which either country presents an armed presence in a given area, how each country will enforce copyright treaties, or how each country will process foreign mail. However, the 20th century witnessed a vast expansion of the use of executive agreements, and critics have challenged the extent of that use as supplanting the treaty process and removing constitutionally prescribed checks and balances over the executive in foreign relations. Supporters counter that the agreements offer a pragmatic solution when the need for swift, secret, and/or concerted action arises. Administrative powers. The President is the head of the executive branch of the federal government and is constitutionally obligated to take care that the laws be faithfully executed. The executive branch has over 4 million employees, including members of the military. Presidents make numerous executive branch appointments. An incoming president may make up to 6,000 before taking office and 8,000 more while serving. Ambassadors, members of the cabinet, and other federal offices are all appointed by a president with the advice and consent of a majority of the Senate. When the Senate is in recess for at least 10 days, the President may make recess appointments. Recess appointments are temporary and expire at the end of the next session of the Senate. The power of a president to fire executive officials has long been a contentious political issue. Generally, a president may remove purely executive officials at will. However, Congress can curtail and constrain a president's authority to fire commissioners of independent regulatory statutory agencies and certain inferior executive offices by statute. The President additionally possesses the ability to direct much of the executive branch through executive orders that are grounded in federal law or constitutionally granted executive power. Executive orders are reviewable by federal courts and can be superseded by federal legislation. To manage the growing federal bureaucracy, presidents have gradually surrounded themselves with many layers of staff, who were eventually organized into the Executive Office of the President of the United States. Within the Executive Office, the President's innermost layer of aides are located in the White House office. Juridical powers. The President also has the power to nominate federal judges, including members of the United States Courts of Appeals and the Supreme Court of the United States. However, these nominations do require Senate confirmation. Securing Senate approval can provide a major obstacle for presidents who wish to orient the federal judiciary toward a particular ideological stance. When nominating judges to U.S. district courts, presidents often respect the long-standing tradition of senatorial courtesy. Presidents may also grant pardons and reprieves, as is often done just before the end of a presidential term, not without controversy. Historically, two doctrines concerning executive power have developed that enable the president to exercise executive power with a degree of autonomy. The first is executive privilege, which allows the president to withhold from disclosure any communications made directly to the president in the performance of executive duties. George Washington first claimed privilege when Congress requested to see Chief Justice John Jay's notes from an unpopular treaty negotiation with Great Britain. While not enshrined in the Constitution or any other law, Washington's action created the precedent for the privilege. When Richard Nixon tried to use executive privilege as a reason for not turning over subpoenaed evidence to Congress during the Watergate scandal, the Supreme Court ruled in United States.The. Nixon, 418 U.S. 683, that executive privilege did not apply in cases where a president was attempting to avoid criminal prosecution. When President Bill Clinton attempted to use executive privilege regarding the Lewinsky scandal, the Supreme Court ruled in Clinton v. Jones, 520 U.S. 681, that the privilege also could not be used in civil suits. These cases established the legal precedent that executive privilege is valid, although the exact extent of the privilege has yet to be clearly defined. Additionally, federal courts have allowed this privilege to radiate outward and protect other executive branch employees, but have weakened that protection for those executive branch communications that do not involve the president. The state secrets privilege allows the president and the executive branch to withhold information or documents from discovery in legal proceedings, if such release would harm national security. Precedent for the privilege arose early in the 19th century when Thomas Jefferson refused to release military documents in the treason trial of Aaron Burr, and again in Totten v. United States 92 U.S. 105, when the Supreme Court dismissed a case brought by a former Union spy. However, the privilege was not formally recognized by the U.S. Supreme Court until United States v. Reynolds 345 U.S. 1, where it was held to be a common law evidentiary privilege. Before the September 11 attacks, use of the privilege had been rare, but increasing in frequency. Since 2001, the government has asserted the privilege in more cases and at earlier stages of the litigation, thus in some instances causing dismissal of the suits before reaching the merits of the claims, as in the Ninth Circuit's ruling in Muhammad v. Jefferson Data Plan, Inc. Critics of the privilege claim its use has become a tool for the government to cover up illegal or embarrassing government actions. Legislative facilitator. The Constitution's ineligibility clause prevents the President from simultaneously being a member of Congress. Therefore, the President cannot directly introduce legislative proposals for consideration in Congress. However, the President can take an indirect role in shaping legislation, especially if the President's political party has a majority in one or both houses of Congress. For example, the President or other officials of the executive branch may draft legislation and then ask senators or representatives to introduce these drafts into Congress. The President can further influence the legislative branch through constitutionally mandated periodic reports to Congress. These reports may be either written or oral, but today are given as the State of the Union Address, which often outlines the President's legislative proposals for the coming year. Additionally, the President may attempt to have Congress alter proposed legislation by threatening to veto the legislation unless requested changes are made. In the 20th century, critics began charging that too many legislative and budgetary powers have slid into the hands of presidents that should belong to Congress. As the head of the executive branch, presidents control a vast array of agencies that can issue regulations with little oversight from Congress. One critic charged that presidents could appoint a virtual army of czars, each wholly unaccountable to Congress yet tasked with spearheading major policy efforts for the White House. Presidents have been criticized for making signing statements when signing congressional legislation about how they understand a bill or plan to execute it. This practice has been criticized by the American Bar Association as unconstitutional. Conservative commentator George Will wrote of an increasingly swollen executive branch and the eclipse of Congress. According to Article 2, Section 3, Clause 2 of the Constitution, the President may convene either or both houses of Congress. If both houses cannot agree on a date of adjournment, the President may appoint a date for Congress to adjourn. Ceremonial roles. As head of state, the President can fulfill traditions established by previous presidents. William Howard Taft started the tradition of throwing out the ceremonial first pitch in 1910 at Griffith Stadium, Washington, D.C., on the Washington Senators' opening day. Every president since Taft, except for Jimmy Carter, threw out at least one ceremonial first ball or pitch for opening day, the All-Star Game, or the World Series, usually with much fanfare. The President of the United States has served as the honorary president of the Boy Scouts of America since the founding of the organization. Other presidential traditions are associated with American holidays. Rutherford B. Hayes began in 1878 the first White House egg rolling for local children. Beginning in 1947 during the Harry S. Truman administration, every Thanksgiving the President is presented with a live domestic turkey during the annual National Thanksgiving Turkey presentation held at the White House. Since 1989, when the custom of pardoning the turkey was formalized by George H. W. Bush, the turkey has been taken to a farm where it will live out the rest of its natural life. Presidential traditions also involve the president's role as head of government. Many outgoing presidents since James Buchanan traditionally give advice to the successor during the presidential transition. Ronald Reagan and his successors have also left a private message on the desk of the Oval Office on Inauguration Day for the incoming president. During a state visit by a foreign head of state, the president typically hosts a state arrival ceremony held on the South Lawn, a custom begun by John F. Kennedy in 1961. This is followed by a state dinner given by the president, which is held in the state dining room later in the evening. The modern presidency holds the president as one of the nation's premier celebrities. Some argue that images of the presidency have a tendency to be manipulated by administration, public relations officials, as well as by presidents themselves. One critic described the presidency as propagandized leadership which has a mesmerizing power surrounding the office. Administration public relations managers staged carefully crafted photo ops of smiling presidents with smiling crowds for television cameras. One critic wrote the image of John F. Kennedy was described as carefully framed in rich detail, which drew on the power of myth regarding the incident of PT 109 and wrote that Kennedy understood how to use images to further his presidential ambitions. As a result, some political commentators have opined that American voters have unrealistic expectations of presidents. Voters expect a president to drive the economy, vanquish enemies, lead the free world, comfort tornado victims, heal the national soul and protect borrowers from hidden credit card fees. Critics of presidency's evolution: most of the nation's founding fathers expected the Congress, which was the first branch of government described in the Constitution, to be the dominant branch of government. They did not expect a strong executive. However, presidential power has shifted over time, which has resulted in claims that the modern presidency has become too powerful, unchecked, unbalanced, and monarchist in nature. Critic Dana D. Nelson believes presidents over the past 30 years have worked towards undivided presidential control of the executive branch and its agencies. Quote, she criticizes proponents of the unitary executive for expanding the many existing uncheckable executive powers, such as executive orders, decrees, memorandums, proclamations, national security directives and legislative signing statements that already allow presidents to enact a good deal of foreign and domestic policy without aid, interference or consent from Congress. Activist Bill Wilson opined that the expanded presidency was the greatest threat ever to individual freedom and democratic rule.